was a big part of that. So
Thank
let me
you.
publicly say that you're going to be missed, my friend.
Thank you. That's so sweet of you. Thanks.
But I'm also going to make you come and visit us. So whatever. You're not going to be gone forever, lady. You're going to have to come and say hello. And when I have questions about policy regarding daycares, you're going to be my call.
I do have one, the last thing on the agenda.
Oh.
Yep.
The notification.
Ah, that's right. So we're going to need you.
Yeah, because we already do that. The only thing is I just looked in the regulation. The regulation states you have until the next business day. That's the only thing, which we all do it immediately, but you need to change that wording, I guess.
Well, you know what? Then after this meeting, send me the language.
Okay.
I mean, you've done this job, you know. Oh, okay. Oh, we've actually hit 1 o'clock. Hi, Senator.
Hi.
Okay, Jean, we've hit 1 o'clock. So how are we doing on our committee membership? We're still waiting for some people.
We're low on membership, but our first guests have arrived.
Okay, and considering that our first guest, wait a minute. You know what? Before we begin, Jean, I don't know if I have the agenda with the speaker order.
Sure, I'll forward you that.
Thank you. This will give us just a minute for everyone to sign on. And if you'll just bear with us, we will begin in the next 2 or 3 minutes.
Well, Madam Chair, maybe this is the time we can welcome everybody, if you are not already done that.
Sure. Yeah. I mean, we can call the meeting to order. I know that we have a few people that will probably be popping in. As always, there are numerous meetings going on at the same time. So for those of you who are watching on YouTube and CTN, you may not see your legislator on the Zoom immediately, but they may be coming in and out. Also, keep in mind that we receive written testimony, and we do a lot of work with the written testimony as well as the verbal. A reminder to all the members on the panels to please refrain from using the chat, as this is live on the internet and the television, and then people can see that. And additionally, it is subjected to FOIA. Representative Exum, I see you have your hand up. Is everything okay? Are you able to get on?
I am on, and I did not mean to have my hand up. I'll take it now.
You know, nothing like making a splash on your first public hearing in the Children's Committee, Representative Exum.
Sorry about that.
No, we love you. You're fine. So, Senator Anwar, as my wonderful co-chair, would you like to share some words of wisdom?
Sure. Well, not much wisdom, but I'll just say I'm glad to be here and looking forward to learning from everyone. I know a lot of people have submitted their written testimony. I've been reading through them. They're very useful. And many of us will be in and out. We are in multiple meetings, but looking forward to hearing from our guests and speakers. So with that, Madam Chair, back to you.
Thank you very much, sir. Representative Wieslander, would you like to say hello?
Good afternoon. It's so nice to see everyone again. I feel like we never left in some ways, but it is very nice to see everyone, and I'm excited to get started this session, or continue the work this session, I should say. We've already been.
That's right, Representative. And as everyone knows, the representative is our vice chair on the House side. And, you know, as we begin this meeting, I just want to remind everyone that as panelists, you can ask questions to the people testifying. We just ask that you raise your hand. I do my best to be able to see the hand, but based on some Zoom lighting, sometimes I don't see that. So feel free to do this if I don't call on you. With that said, I think it's time to welcome our first guest to testify, the one, the only, our Commissioner Beth Bai. Hi, Commissioner, how are you?
Hi, Representative, Senator, and others. Great to be here with you.
It's so nice to have you. So go ahead, start off your testimony, and then we'll bombard you with questions.
Sure. Good afternoon, Senator Anwar, Representative Linehan, Senator Kelly, Representative Dolphinus, and distinguished members of the Committee on Children. My name is Beth Bai. I'm the Commissioner of the Office of Early Childhood. I'm here to testify concerning Senate Bill 122, an act requiring parental notification by child care facilities of certain incidents involving children. Really appreciate this bill being raised. It gives us a chance to look at our regulations and statutes and make sure that we're keeping parents very up to date with anything that happens in programs. So the current regulations that govern licensed child care centers, group child care homes, and family child care homes have significant program requirements pertaining to documenting and reporting incidents that may result in an injury or illness to a child that's enrolled. The OEC totally supports this bill's intention to strengthen the existing requirements, and we look forward to working with this committee to make sure that the regulations that we have are aligned with the statutes. It can get confusing when the statutes say one thing and regulations say another for programs and frankly for our licensors. We just revised our licensed family child care home regulations, and they do require providers to maintain an incident log for each enrolled child to record accidents, incidents leading to a report made to DCF, injuries, illness, or unusual behaviors that occur, and observations of the child made by the provider during the business day. The incident log shall include a description of any accident, incident, injury, illness, or unusual behavior, the date, a time of occurrence, location, and any action taken by the provider, including but not limited to whether the child was transported to a hospital or emergency room, doctor's office, or other medical facility. Family child care providers are also required to notify the OEC no later than the next business day of the death of any enrolled child or injury that results in a diagnosed fractured, second or third degree burn, concussion, or the child being admitted to a hospital. These conditions for reporting are consistent with the federal requirements for the reauthorization of the Federal Child Care and Development Block Grant, which is part of our primary funding mechanism. So those were just approved last March and are in place. Our child care center regulations are right now with the Attorney General's office before they'll go to OPM and come to the legislature. So they're slightly different. They haven't been updated to include exactly what was above, which seems very much in alignment with the bill's intent. These current center regulations and group child care home regulations are similar. The OEC has, in its proposal, move forward with changes to the regulation for child care centers and group child care homes so that the language is consistent with that family child care home regulation language I just outlined for you, and also meets federal requirements. Without changing the intent of this legislation where applicable, the language in this bill could be modified to be more consistent with the current language and regulations, and OEC is really happy to participate in this process. In addition, the proposed requirement for programs to create a written record of incidents that result in an injury or illness no later than 1 hour after the incident occurs may be challenging for programs to comply with in certain situations. When there is an emergency, the staff's immediate response to an incident is often focused on the care of the child, supporting the parent, responding to medical personnel, reaching out to parents, which might prevent them from completing it all within 1 hour. I really appreciate the time to testify today, and we're happy to answer any questions that you might have related to this. We think it's a good idea, just want to make sure the language conforms with the regulations.
Great, thank you very much, Commissioner. And I do have some questions if you can work with me to clarify some things
Sure.
that might help some of my committee members. So you're saying that the federal requirements, and so currently what we have now says no later than next business day. So can you define what that actually means in real time? For instance, if I hear no later than next business day, does that mean it can go all the way to the end of the day and then theoretically it can be longer than 24 hours?
The idea is that it's supposed to be within a day. Like if something happened at 10 a.m., I suppose the next business day includes 2 p.m. and it could be more than 24 hours.
Yeah. And are you aware of the incident that precipitated this piece of legislation?
I am aware of it, and I have staff here who have more details. But we do know that complaint has been resolved with a consent order, and that consent order, like now all of our sort of licensing visit information, is public information on the 211 website. So we do know that there was a hearing, there was a consent order, which means there was a legal agreement recognizing that there were violations, and that is available publicly.
Great, thank you. So I guess the question I have, in your regulations, is it written out what would happen to a center? So if they violate this, is it written out either in statute or regulations, a fine that they would have to pay, a mark against their record? What is it? What's the teeth in that?
Yeah, when programs violate regulations, then they're cited for that. And then they have to come up with a corrective action plan. Or if it's an incident that happened that can't be corrected, that is a significant incident that violates a statute, they come in for a hearing, or there's also often an opportunity for lawyers to meet with our legal team and come up with a consent order, which is a legal agreement, sort of like a settlement about what has to happen. Sometimes those include fines, sometimes they do not. Our goal with compliance hearings and consent orders is to bring programs into compliance, and also new regulations that now have all of our any kind of incident or report posted publicly, I think makes a really big difference. And that's really new in the past 18 months, I believe, that those are all posted. So if members of the committee want to look, they can go to 211 Childcare and look up the history of any program in the state, and it gives parents more information about challenges. So if they were cited, that would also be posted on 211 Childcare.
Right, and Commissioner, that was part of legislation that we did here in the Children's Committee, correct? Right. So just so those who are watching, anytime you go to put your child in a child care center, you can search up that center, go to the drop-down menu and see if they've had any problems in the past. So I'll wrap up my questioning soon. I'm trying to kind of get a whole handle on this. And one question I have is, years ago, before this administration was in place, there was a problem at Solnet, which is a psychiatric residential treatment facility. And Solnet was found they had a finding of immediate jeopardy of harm, which is not really something that happens in childcare, but I'm using this as an example. During that, I found out that when had a finding of immediate jeopardy, there was nothing in the regulations or the law that required other parents whose children are at that facility to be notified of this immediate jeopardy of harm. Now that I hear what happened in this incident, I'm kind of putting these two things together. Is there anything in your regulations that say that if there is an incident at a child care center, even if it is not your child, that other parents are somehow notified that there was a safety problem at the center? And if there is not, why or why not should there be?
It's a really good question. I'll probably have to call on Deb Johnson, our licensing director, to make sure she gives you a thorough answer. So Deb, prepare yourself. But I do know, having been a longtime director of programs, there's often sort of confidential information in an incident report. A parent might not want something that happened to be shared with the whole staff. For example, something that happens often in infant and toddler rooms is one child will bite another, leaving a mark. And it is something that isn't that uncommon when a toddler who doesn't have language skills feels under assault. They are known to bite. And I believe there are ways to set up classrooms to avoid that, et cetera. But when that happens, if that was shared with the whole staff, then the parents start to say, well, who was the child that bit? And it really can turn into a thing and sort of violate some confidentialities that families want to have as things are worked out. It was always the first thing a parent would say, who bit my child? And I did not need to tell them, and I felt that that was a good thing. We are in charge. If that happened under our watch, we have to say, here's what we're doing to prevent that from happening again. But young children, like a 1.5-year-old, sometimes that happens as a developmental sign that the child's in distress or maybe not getting enough attention, and you have to tell, obviously, the parent of the child that's been hurt, but it's not the kind of thing you'd announce to the whole classroom. But I'm just going to ask Deb Johnson to add in anything if she wants to talk about the notification of other families.
Sure, thanks, Commissioner. It is true that a lot of the citations or violations that are identified with programs are dealt with the program, and parents aren't necessarily notified of those violations. There may be many of them. However, if there is a concern at a program that requires the agency to seek a summary suspension, meaning there's an immediate concern for the health and safety of children, in those cases, when we issue a summary suspension, there is a requirement that the programs notify all the parents of enrolled children that the license has been summarily suspended.
Perfect. Okay. Yeah, that's really, I completely understand what the commissioner was saying, the reasons why you wouldn't, disclose the incident in its entirety, but it is very important that if there is a move to suspend a license, that they're notified as to why. Obviously, they're going to be notified because you can't bring a child to a center that has a suspended license. But I just want to make sure, Deborah, that the reason why it was suspended would be included, but it doesn't need to get down to the exact incident, correct?
They would have access to the statement of charges is what it would be called.
Okay. And that makes sense. And so as a parent, that would, I look at these things from a parent side and what do you need to know to keep your children safe? And I do think that that's important. So that answers my question and I appreciate your time. Senator Anwar, did you have some questions?
Yes, I do. Thank you so much, Commissioner Bai, for you and
Yes,
your
Senator.
department for the work that you have done in the last 2 years, and then before that too. Of course, this bill is based on one of the requests that one of my colleagues, Senator Duff, had requested because of an incident. In his testimony, the written testimony that he will probably speak of soon, he spoke of having a way to keep the videos for a certain amount of time. So is that something that's in your on your radar screen as well, to keep the videos for 30 days or so?
Yeah, I mean, I think that's a very fair ask. And I will tell you, having been involved in some investigations, the videos are a part of our investigations when they exist. I don't know, I can ask Deb Johnson again to weigh in, but I don't think that's an unreasonable ask of the senator. And I'll just ask Deb to weigh in. Are there any particular rules now related to saving? Because not everyone has video.
Right, not everyone has video, not all programs. There's no requirement they be retained. I think it's a good requirement to put that in place. We have encountered situations where by the time we're investigating, the video is not available.
Yeah, so we have no problem with that request from Senator Duff, Senator Anwar.
But back to the point that most or many do not have a video to begin with, should that be regulated, that they should have a video?
Well, that's a really good question. Off the bat, I know as a former director, I never had video. I had good supervision of the classroom. And right now, programs are under such duress that that could be a very expensive ask of early childhood programs without funding. So, you know, I haven't had time to think about that, Senator. I'll consider that. Many do, many don't. It's probably 50-50, Senator, would be my guess. And I think if we think about schools, there really aren't, you know, cameras in every classroom. And I know as a teacher, and even having witnessed some of these videos, things can be misconstrued sometimes as well. But, you know, there's certainly plenty of chance to sort of work that through in conversation. But I've seen them used effectively as a teaching tool for teachers. There's a program in Stanford that used them extremely well and actually showed the whole region, you know, video and how they worked with teachers. So they have advantages, but I do see some downsides.
Madam Commissioner, what I would propose is we'll take you up on your and your team's willingness to help us out as we work on this bill and make sure that it is according to the regulations with the language, but also make sure that we are able to have a protection that is in place. So we'll take you up on that.
Thank you so much. Thank you.
Testimony and Madam Chair, back to you, or should we?
Yeah, thank you, Senator. Actually, I think obviously you've noticed that my camera won't turn on. So Senator, if you wouldn't mind calling on Representative Comey while I leave the meeting and come back in.
Sure, Representative
Thank
Comey.
you, sir.
Thank you, sir. Hello, Commissioner Biles.
Hi, Representative. How are you?
It's good to see you. I'm good. So, you know, I was just looking at the way I did reach out to some of my senators to see how they felt about this. One of the things that we were talking about was, how do you determine what is a minor incident as opposed to a more serious, and then of course, you know, if something serious, you know, something requires immediate medical, emergency medical treatment. I think that you know, certainly the parents are almost, you know, always, you know, called as soon as they possibly can. But that is one of those lines that who is going to decide whether, you know, a bump in the head could be minor to somebody and could be major to someone else. And is that something that is concerning of you?
Yeah, it's a good question. I'm going to take us to the language of the family child care regulations, which, you know, then our staff have to determine if they're meeting that standard, and they work on that. But it says injuries, illnesses, or unusual behaviors that occur and observations of the child made by a provider during business hours. So the log has to include a description of the accident or incident, injury, illness, or unusual behavior, the date, time of occurrence, location, any action taken by the provider, including but not limited to whether the child was transported to the hospitals. The other thing is, every program has a health consultant, so it might be the kind of thing that they'd reach out to their health consultant and say, does this rise to the level? I know from experience that it's way better to let parents know if you're questioning, but it's very hard to write the words at which level, because, you know, young children, as a toddler teacher, you know, kids fell down 10 times a day when they were learning to walk. And then I usually, if there was any kind of mark or injury, or, you know, if they hit their head pretty hard, I would always let the parents know as well. So it's saying injury, illness, or unusual behaviors that sort of left up to the discretion of the teacher, and they can, you know, check with their director or their health consultant. There's not a perfect answer to that. It's a good question.
And then when they write the log, you mentioned the log, is it actual the report? Do they have like narrative that accompanies it? Or, because I would imagine, just like if you were a police officer having to write up a case, you know, it takes some time.
Yeah,
and
it does.
Sometimes you're working, as I imagine, as you're writing the narrative, you're working through what happened and all the people involved and the different situation, and you know, making sure that all the I's are dotted and T's are crossed may take some time. And if it's not a serious injury, could it go beyond the 1 hour?
Well, that was one of the questions, is a concern about 1 hour being a very short time because of everything else that's going on in that moment. But the log, according to the family regulations, has to be available to the family the next day. And because you asked a question, generally programs have an incident report and they keep them in a binder by day. And that would serve as the log. And it usually says the date, the teacher, who else witnessed, what happened, were there any marks? And usually at the end of the day, the parent signs it and the teacher signs it. In most centers that I've worked in.
And then thank you. The final concern that had been brought up is that, you know, as you go to leave the classroom to sort of call someone, you're going to leave your classroom sort of out of ratio with that during the emergency, and that there was some concern with that.
Yeah, you can't leave the rest of the children at risk by getting out of ratio to go make the call. Often there are phones in the classroom, but programs right now, as you know, there are big workforce challenges going on in early childhood, but programs are supposed to have, administrative staff who can come in and help if the teacher has to leave the room for that kind of thing. And that's generally how it's managed. I find that programs are very cautious about staying in ratio. It's something that's very clear. The rules are very clear, and programs really tend to follow those carefully.
Okay, thank you. I'm finished with my questioning. Thank
Thanks.
you so much,
Yep.
Chairwoman.
Thank you, Representative. And Representative Green.
Thank you, Commissioner. I
Representative.
happen to own a childcare center,
Yeah.
and I'm actually in my childcare center right now. I'm not fully understanding. I mean, I'm kind of getting the feeling that it's directed towards the family home day cares, which have totally different regulations, because childcare centers are already doing this as of right now. We still notify our parents. The only difference is we don't notify within an hour, and I agree with you 100%. When you're caring for the child, your first priority is the child, and not to get hooked up on this hour issue. I mean, that's going to be next to impossible to do. But we have to write an incident report. Everything is logged. Parents are contacted. Most childcare centers have what I call Facebook for babies, where it's basically, a daily connect or it's Leapfrog, and you have an instant contact with the parent. You've got all the phone numbers right there. So is it geared towards childcare centers, or is it geared towards family daycare?
I really appreciate this question. The reason I spoke to the family child care regs is that those have passed, and the center regs are still with the Attorney General. So they're in the process of being updated. And we want to be consistent about how both are notifying families. Like you're saying, Representative, most programs have this in place now. I think this piece of legislation is just making sure it's in place for everyone and reiterating how important it is. And we would want the center, level of at what level and for what reason do you keep things in a log to match up with family child care. If, in our state, what we're trying to do is assure that there's high quality in family child care, group homes, and center care, and trying to align those high quality standards across all kinds of care. So the center regs will currently mirror the proposed regs, what the family child care regs.
Because, I go back to the hour, notification is very difficult and very
Yes,
challenging.
we agree.
I do, when you look at the regulations, it states you have until the next business day. I mean, I think that's ridiculous. You should be notifying a parent as soon as you can when it's safe to notify a parent. But the hour would be really challenging for centers.
Yeah, so I think, we're happy to work with you on that language. And the language is that the log has to be available to parents the next day, which is a little different than notification. But I think that could be clarified in this language, working with the committee.
Thank you, Commissioner.
Thank you.
Commissioner, this is why we absolutely love to have Representative Green on our committee. Her personal experience is phenomenal. And before I head over to Rep. Foster, I just want to ask something before I forget it. I understand the 1 hour is an issue, and that and the notification of 1 hour is an issue, and that the regulations state next business day. But my question for you is this: it needs to really be same business day, right? Because I'm picking up my kid.
Right.
And the regulations allow me to pick up my kid without you telling me there was an incident. I think that's a problem.
Yeah, and again, I think we can look at the language. I think that's the intent. It was the intent of this bill to have, there may be, as parents, be contacted as soon as reasonably possible, or, I'm not a lawyer. But I do know, as Representative Green said, that when something happens, there's a lot going on at a center. If a child, I haven't luckily never had too many serious injuries, but there were a couple of broken bones. And just that period of time from the time a child lands on their leg, to the parent coming or an ambulance in some cases getting there. And then generally as director, I would ride with the child to the hospital, and then there are people back at the program trying to just make sure all the other kids are safe and healthy. So, every incident is different. So I think you might have to think of, I'm sure there's an attorney on this call, some kind of legal standard that establishes that the program did their best to reach the parent as soon as practicably possible.
Yeah, and if we change this to be that they are required to notify the parent by the end of the day or close of business, rather than within the next business day, if we change that, then we will have a stronger regulation than the feds require. And then if we put that in statute, do you then need to go through the whole regs process again? Or can you just say it's now in statute?
Well, once it's in statute, that's the law too. And that's what gets complicated for providers. And they're sort of looking at both. And so are we when we're going out on inspection. So I might ask Mike Curley to address that. I believe our attorney's on the line.
Yes, I'm here. I'm trying to unmute and turn my camera on here.
You're unmuted. Oh, your camera's on. There you go.
Hi there.
Hello. So yes, if the statute were to contradict what's in regulation, then the statute would overrule the regulation, and that's what would legally apply. So if there were a stronger requirement in the statute, as soon as that statute is enacted, that would be the requirement for childcare programs.
But would it be difficult for centers and daycares to get that information because it's in statute and not in regs, and if they're consistently looking at regs? So if you have to then make that into your regs, how long does that process take?
Years, 3 years, 4 years. It's not, Mike, I'm not overstating that, am I?
Well, I think the typical process for us to make, many revisions to our regulations is a very long process with a lot of review, and that has historically taken years for those changes to be made. If we were talking about one technical change to make the regulation consistent with the statute, I think it could happen much faster.
But just in case, if we're writing that, and this is language that everyone feels is necessary and the proponent of the bill agrees, and you guys are all on board, then we can write into the statute that there would be a requirement of notification to centers, correct?
Yep.
Okay, great. Thank you. Representative Foster.
Thanks so much, Madam Chair. Commissioner Bai, it's good to have you here and here today. Thanks so much for being here. I am really interested in hearing this conversation of what's been happening about reporting standards and also about defining what is a serious event. It brings into question something that I've been in communication with a lot of families about allergen exposures and the seriousness of those and how quickly they get reported. I happen to have a child with celiac disease and very times. Yeah. very oftentimes when those exposures were happening at school, they would be like, oh, well, she didn't react. So we just didn't think it was important. But then we were in like serious medical distress hours, days later. And they were like, oh, but we thought she grew out of it because there was no reaction at that time. And that was like a recurring occurrence.
Oh my goodness.
You know, and again, so what this begs for me is if there's a specific type of violation, I'm not sure where that is on the serious end of the spectrum. To me, it felt as a parent, and I think as a parent, typically any experience seems really extreme when it's happening to your child. It's hard to contextualize that as a mother or a father. You're watching something, your child suffer, everything feels pretty intense. But, you know, if there's a specific type of adverse reporting that's happening repeatedly, is that something that could be cataloged and captured in this as well? Maintaining video records becomes really important to confirm an exposure to an allergen, as I'm sure it's also important in a whole slew of other adverse experiences. And so I want to sort of vocalize my support for that, and then ask if you have ideas of how we might be able to capture protection for children who have exposures and adverse incidences that might be happening at the school. They can result in hospitalization, but not immediately. And so the severity of that doesn't seem as, you know, persistent, I think, in a daycare center setting.
Yeah, I so appreciate this question. Celiac disease is certainly more prevalent than it was when my daughter was 2. But you're right. The thing about it is that if they're exposed, it's not like an allergy where there's an EpiPen. It's something that can have days, and if you already have a failure to thrive child because of the celiac disease, it totally can easily lead to hospitalization and severe illness, and set them back months. And I don't think everybody understands that, especially where like there's gluten sensitivity and then there's celiac disease. They're very different things. And it's very different than an allergy because it sets off a whole autoimmune situation. And I'm sorry you're dealing with that, but I will tell you it's led our family to very healthy eating. So certainly the program should report that right away, any exposure to an allergen or something like that. Now, as I read this exact language, I'm not sure that particular situation is taken into account. So I'm just going to ask Deb from licensing to weigh in. Is there anywhere else in the regulations or statutes related to allergies or reporting that? Or regulations?
Well, there is a requirement about if a child has a condition where they need special care while at the program, they need to have an individual plan of care. That's signed off by the parent, and the provider and their physician has looked at it. So it would outline a plan of care for that child. Within that individual plan of care, there might be information that they've all agreed to how that would be managed. And so we would look at that if there was an incident to see if they followed the plan of care. The other thing I want to point out, in the family regulations currently, there is a separate section of the regs that talks about information must be given immediately regarding an accident or an illness or an injury to the parents if that occurs. So that already exists in the family regs. I was just looking at the center regs to see what it says there about that. But notification, immediate notification, it doesn't say the next day or within 1 hour, it says immediate notification to the parents. So that's a good thing that's there already.
I'm wondering if this is something that could be practice guidance as opposed to legislative change, because I think in my experience, they were like, oh, well, they thought it was a problem, but look, it wasn't. And then it might be a different teacher. It might've been a sub when the incident occurred. And the transfer of that information, you know, we're talking about daycare crisis, you know, levels right now where staffing is moving. Sometimes ratio means that the adult supervision in the classroom is fluid, which can mean relaying this information about protecting the child from an adverse incident, but also from reporting if an incident occurred, or knowing that an incident occurred because you might not be familiar with the child, really challenging.
Yeah, and the regulations do specify this individual plan of care needs to be signed off by all staff who are responsible for caring for the child. So if there was a change off of staff, the new staff should also have signed off on the individual plan of care.
Okay.
Yeah.
My additional question is sort of around the reporting to parents and perhaps to OEC. I can think of times and occasions where I have friends whose children are in childcare, where a daycare provider provided a corrective action to a child whose behavior was inconsistent with what the daycare center wanted, and where the provider provided correction in a way that was inconsistent with the daycare standards. So imagine a more authoritarian approach to correcting child behavior, perhaps not something that a parent would be comfortable seeing, and corrective training or action could have occurred. The amount of reporting that occurs with a staff person who might have repeated corrective action. So let's say a child comes home, they were corrected for misbehavior. Maybe that correction resulted in a bruise that was observed. The staff was spoken to. How often is that information being cataloged in the day with OEC? And how many times is a staff person able to be corrected when there is an incident, with that being sort of tolerated by OEC?
Yeah, I really appreciate this question. First of all, if there was a bruise, that should be reported to OEC, and OEC would come in, likely with DCF, to investigate that case, and it's taken very seriously. In the cases that I've seen, in most cases, a staff person is dismissed. I can't speak to every case, but the ones that I've been engaged with since I've been commissioner. But I'll ask Deb Johnson. Deb, I told you I was going to manage most of these questions today, but there's some really great questions from this committee in detail. And I think because this is about notification of parents and childcare, it's really important to have these conversations about what's in place now. So I'll have you weigh in as well, Deb, on this.
Sure, thank you. I appreciate the interest. The childcare centers, and the regulations differ a little bit for each of them, but childcare centers have to have their own policy regarding discipline practices. So they need to ensure staff follow those policies. Obviously, if we get a complaint, that's one of the first things we look at, not just what happened, but what is the program's policy, and are they following through and enforcing that policy? Childcare, a family childcare home, they need to inform parents of their discipline or their child management practices and follow those. I don't know if that answers your question, but
I would just say, Representative, there certainly aren't many chances, because my experience has been that if there is discipline that includes any kind of physical hands-on child that results in an injury, that staff member is generally let go. And if not, that's often a part of a corrective action plan.
And so what I'm wondering then is, that person, can then they be employed at another daycare center?
Oh, well, that is a question that, there was a situation about 1.5 years or 2 years ago where somebody was let go and then employed somewhere else. So every time a person is hired, that program has to put them through a background check that includes a DCF check, so that if there had been a DCF finding in the case of abuse and neglect, that would show up on an incident check. But if not, that person could be employed. And we really encourage careful background checks of staff. And to your point, Representative Foster, right now there's a severe staffing shortage, and programs are looking to hire as soon as possible. So it can happen without careful background checks, but there are checks in place, in that Connecticut requires a DCF background check in addition to the fingerprint check, which does make, I think, a big difference in our state.
Okay, and this is my last question.
Sure.
I promise. But then what I'm curious about is if that information then becomes accessible to a place like care.com. So for someone who's been repeatedly removed from a daycare center and then they become a private nanny through care.com or child care provider, is that, you know, is there a way to encourage incident report sharing through a venue like that?
Care.com, I'm not sure what their background check requirements are. I don't know if any of my team are, but my guess is it's not as thorough as childcare licensing checks. You know, this is why we need high quality, accessible early childhood education in Connecticut and across the country, and make it more accessible, because it's out of the reach of many families, the high quality care. And we're seeing the strains in the system from COVID, leaving some of these questions, you know, that there are all kinds of challenges in the field, but we do know that licensed care, and we really ask parents to trust licensed care, because you have that unannounced visit, because you have this very public background check that goes through multiple registries, and you have the 211 child care with the licensing inspections being posted, that there's a lot more information for families. So it's important that we support the licensed options and that there are enough. But I mean, I'm sure Rep. Green could tell you that programs are under severe strain right now.
Thank you so much.
Yep, you're welcome.
Thank you very much. Representative Wieslander.
Thank you, Madam Chair. And thank you, Commissioner, for being here.
Sure.
I wanted just to, I think, just share I'm grateful for your time today and sharing your perspective on this. I, long time ago, worked at a child care center, and it's a busy space with lots of going on. And even with multiple teachers or staff in each room, it can, the time goes very quickly. And so I recognize and understand the challenges that a 1 hour notification process may pose. But my question would be, do you think that would, based on my experience, again, that was a long time ago, would end of business day, that seemed to be the practice that we had in place at the center that I worked in.
Mm-hmm.
I would anticipate, hopefully, that wouldn't put undue hardship on centers to make sure that that continued communication and trust between the provider and the families is there.
I totally agree. And my experience is, and I'm sure other program directors would say this, it's way better to call the parent ahead than to have them show up and the child has a bruise on their forehead because they bumped their head on the climber or something like that. That then the parent has time to process, and they're not walking in and saying, what the heck happened here? And by the way, parents tend to, if you tell them their child has a bruise on their head, they tend to picture something worse than it is in most cases. But I do think that as soon as practicable is definitely recommended. And as I said, I think an hour is too short, but most programs probably will contact the parent within an hour. You want to get to them as soon as you can. So, but I do think there needs to be a little more wiggle room for programs because of all that can happen if it's a significant incident.
Okay. Thank you very much. I appreciate that.
Thank you very much. And with that, I see no other hands. So Commissioner, I think we're all set for today. But I do think that we've had some really great discussion here. And we're going to have to reach out so we can find some language that works. I just want to put something on your radar. We don't have to talk about it now, but just so that you're prepared when we have the meeting. We talked about, my wonderful co-chair talked about video. And as we move forward with this, one of the questions I am going to have is if you know of centers that do have video, and if you would support centers that primarily care for disabled children, if we were to make the regulation that they have to have cameras. So we could talk about that moving forward, because I know it's not in this bill, but as we get together for a meeting, since we're on such a short time frame, maybe you guys can look into that and be prepared for that when we chat.
Super, thank you. And thanks to Senator Duff for his leadership on this bill.
Absolutely. Thank you so much, guys.
Bye-bye.
Next, we would like to please call Sarah Egan, the child advocate, and after that, we have Representative Nolan.
Yes, hello, everyone. Good afternoon, Senator Anwar, Representative Linehan, Senator Kelly, Representative Daphne, and all the members of the Committee on Children. I wanted to clarify that this testimony is being submitted today on behalf of the Office of the Child Advocate and Dr. Kirsten Bechtel, an emergency department pediatrician from Yale New Haven Hospital, in our role as co-chairs of the state's Child Fatality Review Panel. The obligations of the OCA are to review, investigate, and make recommendations regarding how publicly funded state and local system meets the needs of vulnerable children. And the Child Fatality Review Panel requires the panel to review the circumstances of sudden unexpected child deaths and critical injuries that involve children and facilitate prevention strategies for children and families in the state. And we wanted to offer testimony today on behalf of the House Bill 5155, an act concerning the safe storage of cannabis, cannabis products, and prescription drugs. Did submit our written testimony. So I won't read it all to you, but really wanted to offer testimony today to underscore that, boy, this is really important, right? The storage issues are really, really important. I know there's language in the bill that requires public health information and other documentation from consumer protection regarding safe storage of cannabis and prescription drugs. It will be essential that consumer health materials, as referenced in the bill, and warnings referenced in other warnings that referenced in the proposed bill, are explicit regarding the dangers of accidental ingestion or overdose of cannabis and other substances by children. Potentially, the bill language could be more explicit regarding that public health messaging. Our testimony has some statistics in it that I wanted to bring to your attention, which is since 2019, cannabis ingestions and exposures by children and adolescents that have been reported to Connecticut Poison Control have increased by over 300%. Ooh. Right, that's a big number. The majority of these exposures are accidental, meaning that children are inadvertently consuming these products. Inadvertently consuming these products, usually in the form of edibles, gummies, and chocolate. And that's without having any dispensaries yet in Connecticut, right? So folks, can access this in any way. On any given week or month, the OCA receives notification of critical incidents involving very young children, typically children under age 5, who have ingested some edible form of cannabis. Usually that looks like candy, chocolate bar, gummies, Starbursts. We also have cases that we review that involve older children, middle school age children who may have some sense of what they're ingesting, but no meaningful sense of how much or what the impact is. Children as young as 5 years old, younger than 5, who consume cannabis are most likely to be symptomatic and require hospital care. Even a small exposure of cannabis-containing product can lead to significant symptoms in children. Ingestion of THC in children can lead to a wide range of serious medical consequences, including coma and seizure. Connecticut is one of the strongest cannabis laws in the country, if not the strongest. And the safeguards in Connecticut's law are common sense, such as setting dose and serving size limits. But if cannabis is stored in a way that is still accessible to children, then these safeguards won't amount to what we want them to be. And therefore, a public health campaign that's focused on caregiver and youth education about safe storage of cannabis product is essential. Although this bill is about cannabis storage, I did want to take the opportunity as a co-chair of the state's Child Fatality Review Panel to let you know that we are collecting data around child fatalities in a little bit of a different way over the last 2 years, and making sure that we're including toxicology information that the medical examiner's office finds that are present in a child's body at the time of death. And I can tell you that for last year, and again, this data is preliminary because it can take several months into the next year for all of the child fatality data to be complete for a variety of reasons. But what we know so far is that about 106 deaths reviewed by the Child Fatality Review Panel, More than a third of those children had illicit substances in their system at the time of death. That includes cannabis, fentanyl, alcohol, and other substances. Children in this 35, it's 35 children. Of the 35 children, 8 ranged in age from 4 weeks old to 17 years old. About 7 of those children's deaths we know so far are the result of intoxication, ingestion, overdose of a substance, typically fentanyl, but not always. Manner of death across those 35 children include accident, usually motor vehicle, gunshot wound, and suicide. I thought that was a startling statistic. Even though we know the presence of substances impacts our children in many ways, I thought it was important to share that here. We will continue to share that kind of data. Fentanyl ingestion is also a very significant concern for young children. And unfortunately, that's something we've seen that's on the rise as well. And we are talking to folks, and I know that public health partners across the state are looking at this, but we have to have a really strong, multifaceted public health campaign to talk about how to keep substances out of the hands of children, and to educate children who think they know, but they don't know about what some of the dangers of these substances can be. And one last story I'll share with you is a very unfortunate story of a family of very young children. And a few months ago, and one of them found somewhere in the house a candy bar. And their grandparents said, oh, well, if you found the candy bar, you got to share it with all of your little siblings. The oldest of the children was 6 years old. The candy bar was a cannabis candy bar. And the youngest child was in critical condition in the hospital as a result of that ingestion, all unknowing, right? All unknowing, right? And so, I think, we need to be paying attention to that. And what more can we do? I think this bill, Connecticut's bill, is a good bill, right? And these provisions before you today are good provisions. And I think the devil's going to be in the detail when it comes to the packaging, the warnings, and the public health campaign, including billboards and other things to say, some of which are out there already, but to talk about this issue in particular, this issue, So that's what we wanted to highlight today for you. And thank you for hearing our testimony. And we're happy to work with the committee on language on any aspect of this. Thank you very much.
Thank you so very much. I really appreciate every time you come here. But I always wind up at some point having my head in my hands because these statistics are just so alarming. As you know, this bill is really close to my heart. It's something I've really been thinking about. But you said something that kind of set something off in my head. And so I just want to go over that with you. You said that we need to be more explicit in the warnings. Give me an example of what an more explicit warning would be.
Okay, that's a really good question. I'll actually pull up the bill language. Okay, so
while you're doing that, I mean, like in New York, right?
Yep.
There are things that say, cigarette smoking will kill your fetus. And I remember that there were people going, well, that's just too much. And it's, I don't want people reading that. And it's an alarmist attitude. But it's true here, right? I mean, it's true.
I'm trying, of course, now I can't find the language in the bill quickly. But I think it spoke generically representative to, as bills sometimes do, right, to public health. And I think we might just want to unpack that to say the dangers of ingestion, the impact on children, health impacts for children under the age of 1, under the age of 6. I mean, I think there's lots of different, components that we can pack in here. The most serious ingestion injuries, even some of the information we put, Dr. Bechtel, it's really Dr. Bechtel put that part into the testimony around the impact of cannabis on children under the age of 5. That's something to be explicit about, right? I think there is this perception that that cannabis is harmless or relatively so, and of course, for particularly very young children, that's absolutely not the case. So I think, almost if we think about it, what would the black box warning look like, right? extremely toxic for children of, I mean, and potentially fatal for children under the age of 5, right? But I think, that's where I would defer to, the public health experts around that, which I am not, I'm a lawyer, as we know, but I'm trying to spot that issue for the committee, that I think we want to unpack that and be really clear about what kinds of black box warnings we need here.
Yeah, and this legislation is actually going to be more than THC and cannabis. So I want to point out that the THC, obviously, the warnings will be at dispensaries and on packaging themselves. I agree with you that there needs to be a public campaign, but additionally, we would like to have safe storage information also on opioids and through pharmacies. So we need to make sure that we're hitting all the right marks here. I very, very much appreciate your testimony. There's a lot of work to be done here. Members of the committee should really take note that what we're talking about here is going to include a dollar amount. It is. We're going to pay for this, and ultimately, we may be able to find some funding sources that don't go to our yearly budget, but we need to make sure that we all understand that this is worth the money. So I appreciate you pointing that all out, Sarah. And now I'm going to see Senator Anwar. Do you have any questions for Ms. Egan?
Yes, I do. Thank you, Sarah, for your testimony. I truly appreciate all the work. I feel like saying Professor Egan all the time because you are so professorial. But I truly appreciate your insight and help in the work that you're doing and your office does. I think later we'll hear from one of the Pharmacists Association representative about their concern about the scope of the bill and the technical language to make sure that we look at the highest risk areas. So it would be a worthy conversation later to try and make sure that we become focused on the high risk areas. And that's part of the area of opportunity. One of the things is the recreational part is the part that I think we have to figure out how do we navigate the recreational, the edibles. And again, should we actually also look at the edibles, which are looking like candies or cookies, because that we train from day one, our children, candies are way try to, which may have its own issues, that's how we try to justify good behavior or give them snacks with candies. And then those things are no longer safe as they used to be. So I think these are things that we may have to assess as a committee as well to see if there are areas of opportunity to fix that so that the risk of some of these accidents can be minimized. I think I wanted to touch on that. And from a money point of view, my thought was that, again, there's going to be some recreational cannabis revenue and also the settlement for opioid settlement. That may be an area that we can use for educating and having a campaign to be able to pay for that. So just some thoughts, and maybe you can reflect on them.
Yeah, I think that's absolutely right. I was actually thinking about one other thing while you were talking, which is, one of the other issues that we see out there is when marijuana that kids obtain is laced with other things like fentanyl, right? And that's something also that's showing up on the horizon a bit. So that youth education component, right? Don't put things in your mouth at school that didn't come from your house, that you didn't buy at the store. There's so much room for health education with our kids in particular. And Senator Anwar, I'm glad you referenced the opioid settlement money, because it's going to be really important as that legislation comes up to look at where dollars can be steered in a 2-generational way for adults and for children. So we're here to support that work in any way that we can. But that the health education, the education that goes on in schools, the billboard education, there's going to be a lot of work to do, I think, here.
Thank you, Madam Chair.
Thank you very much. And seeing no hands up, I just have one last question for you, Sarah. Sarah, it's come to my attention that you have a wonderful person in the office who, unfortunately for us, but fortunately for her, is retiring today. Do you have Mickey Kramer there with you?
I do. I'm trying to drag her up to my
Mickey, it's your
computer.
last time. You
Oh,
got to
yeah.
get on camera.
Oh, yeah. Here.
Listen, I know, Mickey, that this is not your thing. And so I apologize for putting you on the spot this way. But I want to be able to say publicly that you have been instrumental in many great pieces of legislation that we put forward through this committee. And your work in general has saved lives, and it has made lives better. And those are kids' lives. Everything that you've done. How long has it been now? How many years were you in this position?
Almost 24.
Oh my gosh. We are going to so miss your insights and your brilliance, but we're also going to miss you as a person. I've loved having you come, and we're working on some pretty hefty things in my office, but we've also had some really good laughs, because you need to when you work on all these heavy things. But you've done a wonderful job, and on behalf of our entire committee, we want to thank you for your 24 years of service. And I hope that you walk away knowing that you've done an incredible job for the children of Connecticut.
Thank you all so much. It's been an incredible, it's been just an incredible privilege. That's all I can say. Thank you.
Well,
Thank you so much.
Oh boy, I think I'm in trouble.
You are in trouble, but
I am.
she deserved to know how much she means to all of us and the great work that she's done. So thank you very much, Sarah.
Representative, and thank you very much. Yeah, we're going to miss her too, but glad to have all of you as partners in this important work. And Faith goes next. So, they're all
Don't
leaving.
even start with that.
Because
that's I'm going to work on that and make sure that doesn't happen.
All right,
So,
thanks
all
very
right,
much.
thank you, Sarah. Next, we have Representative Anthony Nolan. Hello, sir. Are you here with us?
I am. How are you?
We're well. How are you, sir?
I'm good. Thank you, Rep. Linehan, and to my fellow colleagues and senators that are present. It's so good to come before you. I've been listening to everything from the start of the meeting, which is exciting because this is one of our most important committees that we have in regards to children. A lot of the stuff has been said that I was going to mention, but I'm just going to repeat a few things. So I appreciate your time to allow me to come before you and testify on a few things. One of the most important things Sarah just got through talking about is the storage of cannabis and some of the hardships that we're facing in regards to some of our illicit drugs out there, some of our opioid issues when it comes to people are not storing them correctly, and also the packaging being so colorful and prompting the eyes of our children. I'm just hoping that we could tighten up on ensuring that even if the package comes in complete black, it's just more beneficial for our children. As you can see in New York, they're kind of dropping their guard on that, and there are billboards that have little Pac-Man monsters on it that attract kids, and there's just some things that are too attractive for our kids to be able to have the sense sometimes to recognize that it's dangerous. It's not a snacky kind of candy that they might be trying to test, that there is a lot of danger to it. So I do agree with the public campaign pushing on information to go out there to help stop some of the issues that we're having with children mistakenly taking candies by accident that are dosed in some of these dangerous chemicals like fentanyl. So I'm in very large support of that bill, which is the HB 5155, I believe it is. That is one of the topics that I wanted to raise. A lot of the things on the agenda are great things, but pointing out also the notification by child care facilities is another huge one. There is a slight concern in regards to the hour time limit that everybody was talking about, because sometimes within that hour when the facility calls the police department or the fire department, and by the time we get there, and by the time they're done with all the stress and all the levels of anxiety that build up, that hour disappears so quickly. Between the time of them getting the teacher to take over the class, for someone to go down to the hospital with the child, the ambulance ride down to the hospital, that all is such a quick amount of time that people sometimes don't realize how fast time goes when you're spending time trying to help a child that has been injured. No matter what the injury, the time still goes by really quick. So I'm hoping that, in talking with some child care centers and some places that take care of children, that conversation has come up. And we know how important it is to contact the parent. And we're not trying to drop the guard on contacting the parent. That's one of the most important things we need to do. But the reality of the situation is tougher when we're all in action and we're all trying to get that child the care that they need. So I was hearing earlier, Rep. Linehan talked about maybe a couple of hours or before the end of the day, or as urgent as possible. Get in touch with the parent. But I think anything longer than the end of the day would not be acceptable. But I think before the end of the day would be more appropriate to try and make sure that the parent is contacted, because of the things that go on within that first hour. That's a hard thing. And the other bill that I'm so excited about is the mental health bill for our children. Information going out to the parent. I want to kind of focus on the child and some of our young adults, because the police do give out certain information. We have a yellow card that we give out. There's a 211 card that we give out. But when we're giving out that information, it's not simplified. It's just a number, call this, and then that's it. I do believe that there are young children, sometimes as young as 13, that we ought to make information available that is, I don't want to say animated like a cartoon, but animated enough for them to understand that there is help for them. And some parents are leaving kids home at the age of 13 and some younger. So when a kid goes through crisis, there ought to be some kind of trifold flyer that we give out, so they can understand that, these are some of the important things that when you go through these things, that there is help for you. We always want to push calling your parent, but sometimes there's a matter of time where a kid needs to call somebody other than the parent to get the help that they need. And that person might have to be the in-between person between the parent and the child sometimes, because there are times where that is very difficult. So knowing that there are things that we already do give out, I really think we need to simplify them for our young adults and our kids between the ages of 13 and maybe 17. So they understand that there are these places out there, and we need to simplify it in some kind of trifold, I think, that includes maybe the suicide hotline, maybe domestic violence. If we put it all on one track, then all those items are there for everybody to understand. But I really think it's important to simplify things for our youth, and that our officers on the street have them available. I really think, in the language, I know it says that the officer has an option to give them out, but I really think that should read shall, because that's how important this is, that we make sure that we give out a pamphlet to those in need, so that we can make sure that they're always going to be okay and have something to read.
Representative here, for those on the committee who aren't aware, Representative Nolan is also a police officer. And this is your concept. This is your bill, Representative. And so thank you for clarifying that you'd like to see this aimed at the ages of 13 to 17 years old. I think that does change it a bit because it's not how the bill was drafted. So if you could just answer a quick question for me. So you head to a call and there is, let's say you go to a domestic and there is a child there. Do you envision that this pamphlet would be given to the child and says, you know, there is family help, and this is who you can call, but talk to your parents first? I mean, what if talking to their parents could be a dangerous situation for the kid?
That's why I think everybody in the household that's involved in the domestic should be able to have one of those flyers.
Do you think there needs to be 2 flyers, one made for children and one made for adults?
I do, yes.
Okay.
No, and I think that in conversation with others, a lot of people thought that was very difficult. But working with some of the youth that I do in the community, they have actually, and I wish I could have sent it to you earlier, they have actually come up with a concept flyer that could be recommended to do something similar. I'm going to try and get that from them later on today and send to you, and maybe you could hand out to the committee to look at.
Sure, that'd be very helpful.
It's something that the youth felt was necessary, especially when we just had a really horrific suicide murder in New London. And some of the kids that were friends of the young lady brought this up as a very big concern. And they just wanted to know, you know, how can we have a voice in providing what we think is necessary for kids our age to be able to have something to go to and to work on that would help us.
That's heartbreaking, but at the same time, extremely encouraging that young people want to take an active role in helping in the situation. So thank you, Representative. I know that we will be working closely on this in the future. Senator Anwar, do you have any questions for the representative?
I do not have questions, but I have a comment. I just wanted to thank Representative Nolan for his wisdom and the experience that you bring to the table with the empathy and understanding. That really helps us be better at what we can do. And then I cannot thank you enough for your time and your commitment and your help in so many different steps in whatever you're helping us with as well. Thank you.
I agree with him, Representative. Thank you so very much. And we will be in touch to further flesh out the details of the legislation. So thank you, sir.
Thanks again for all the hard work that you guys are doing. I do really appreciate it. And more people than you know do appreciate and are paying attention to what we do. So it is amazing work. Thank you again.
Thank you, sir. Well, that was nice. Next we have Liza Andrews from Ccadv. Hi, Liza.
Hi, Representative Linehan, Senator Anwar, Senator Kelly, Representative Doffness, members of the committee. Thanks very much for having me today. Ccadv is the state's domestic violence coalition. We are a membership organization of the 18 direct service domestic violence organizations across the state. I just wanted to quickly discuss Senate Bill 123 and then what Representative Nolan just discussed, House Bill 5154. So starting with Senate Bill 123, and I do apologize, I just sent my written testimony in, so the clerk should have it and be able to get it up shortly. So Senate Bill 123 seeks to expand the address confidentiality program. This would include, the expansion would include victims of kidnapping, human trafficking, and then those individuals who have had, who have filed or had a petition filed on their behalf for the termination of parental rights. We support the expansion to these groups. Currently, the address confidentiality program is specifically the crimes and victimization included under it really fall within domestic and sexual violence. So the reason I bring that up is because Connecticut General Statutes 54-240B, which is not one of the statutes you're looking to amend in this bill, that statute does say that each application has to be completed by an application assistant. And then it goes on to say that the Secretary of the State's website has to provide a list of application assistants on its website. So the actual creation of the list is an administrative duty of the Secretary of the State's office. Currently, because the address confidentiality program really covers just domestic and sexual violence, and I know you're going to hear next from my counterpart at the Connecticut Alliance to End Sexual Violence, all of the entities listed as application assistants are either members of CCADV or the member programs of the Connecticut Alliance to End Sexual Violence. So in terms of the expansion to these three other categories, we would just want the Secretary of the State's office to have a plan for how it's going to expand its application assistant list. Certainly for CCADV, our member organizations work with human trafficking victims, but there are also organizations like Love 146 and the Connecticut Institute for Refugees and Immigrants that do a lot of work with human trafficking victims. And then in terms of victims of kidnapping, and then someone who has had a parent had their parental rights terminated, they may be victims of domestic violence and receiving services from us, but they may not be. So the application actually requires the application assistant to attest to the victimization. And I just think for some of these expansions, our advocates will not always be able to attest to that. So, in those situations where they're not receiving domestic violence services, we would not be able to assist with the application. So again, no problem with the expansion. Just want to make sure the Secretary of the State's office is thinking through how it's going to expand its application assistance list.
Yeah, that's a really great thing to point out. Thank you. That's why we asked you to come and testify at these things. Just in talking it through with me in my head, the victim's advocate would be a really great place, maybe to do that. We just want to make sure that they would be involved somehow, and we will absolutely address that, Liza. Thank you very, very much for pointing that out. I do think also as we go through for the substitute language, we will find new wording for a lot of that as well, and we'll kind of drill that down. And of course, I'll be in touch with you to make sure that your organization is in agreement with that as well. So, thank you very much. And you said you had two bills you wanted to talk about today?
Yeah, so I also wanted to talk about House Bill 5154, and that's the provision of information regarding children's mental health and domestic violence by police officers. So again, we have no problems, with the proposal. Think it's totally fine. Did just want to point out that Connecticut General Statutes 46B 38B, specifically subsection F, does already require law enforcement to hand out information on domestic violence. And for that, we do provide free of charge tear-off pads. We provide about 7,000 a year in both English and Spanish to all of the police departments across the state. There's about 121 between municipal, state, tribal, and university. And this includes just some basic safety planning information, as well as how to contact the statewide domestic violence hotline. And then similarly, CGS 54203 gives the Office of Victim Services within the judicial branch the power to direct law enforcement to distribute information about information to crime victims. And for them, they also provide tear-off sheets and tear-off pads to police departments. And that also includes information about domestic violence. It also includes child abuse, sexual assault. So some of this stuff was already being done, but I do think particularly the way Representative Nolan kind of just laid out his vision for it, there could be something different done to speak specifically towards children. So we'd be happy to work with the committee on, what that ultimately looks like.
Yeah, that's great. Thank you. So I'm going to ask you a question you may not have the answer to right off the bat. It's okay. Get it to me. But you said you do, was it about 7,000 pads you distribute a year? Mm-hmm. What does that cost you?
Oh, I don't know. It's a few $1,000s. There's 20, it's just this size. There's 25 sheets per pad. I think it's a few $1,000s a year that we spend to print those and mail those. Probably a little more because that doesn't include mailing. I just see the printing end of it.
It's just worth every penny.
Yeah.
Yeah.
I mean, we think so. I mean, the statewide model policy on police response to family violence also requires that they provide that information. So we want to give them the tools to do this. So that's why we pay to print those out and send them out.
Yeah, and as we're thinking about this, and something that I discussed with Representative Nolan, we see that domestic violence is often kicking off some mental health issues, like it's trauma, right? So it makes sense that we give information to children experiencing trauma. We give them information on how to begin to heal from that trauma.
Yeah.
And so many people will say, well, you're adding mental health in to domestic violence, and so since you are the resident expert here, can you just confirm for us that those two things actually are related?
I mean, for sure, both if we're talking about intimate partner violence, for sure, the direct victim has a whole bunch of trauma, but absolutely the children who are witnessing that stuff in their home have an immense amount of trauma. It's one of our other big focuses this session. It's before the Appropriations Committee, but for sure, we need to do more for kids that are witnessing this, because we know it's a learned behavior. No kid is being born and saying, I hope to grow up and be an abuser someday. And they also don't grow up and say, I hope to be victimized someday. I mean, it's a learned behavior. So we definitely want to start figuring out more how to get at that intergenerational trauma that kids are experiencing.
Great, thank you. And just a programming note, we do have on Friday the joint public hearing with the Public Health Committee on 5001, which a provision in that bill also includes the creation of a trauma coordinator through SDE, so that we can have trauma-informed practice in our schools and have someone overseeing that. So if you would like to take a look at what that bill is offering and submit your testimony for Friday too, we would love to have you.
I printed it out. It's
all 103 pages.
I'm getting to it.
You're a real trooper. If you want to know the exact location, just send me an email. I'll let you know what section to look at. But
sure.
Thank you very, very much for your expertise and your testimony. Are there any other questions? Seeing none, I believe. Oh, wait, Rep. Dauphiné. Go ahead. I think you're muted, Representative.
You are. Good afternoon. You missed my good morning, so I got you a good afternoon. Just a question. I don't know if you're the one that would, best answer this, but can you provide clarification to the petition process of the removal of parental rights, such as the case that typically led to the removal and the reasoning to include these children on the residential address confidentiality list? Are you able to answer that? Or Madam Chair, maybe you could direct me to who could best answer
that. Can you repeat that? Because you went out for me for a minute.
Oh, sorry. Can you provide clarification to the petition process of the removal of parental rights, such as the case that typically led to the removal and reasoning to include these children on the residential address confidentiality list?
Absolutely, because and now keep in mind that this is a voluntary program, so it would require someone seeking out to be removed from the list. But many times, if someone has terminated parental rights, there is obviously reasoning for that. This is a court proceeding. It's not something that just happens because they feel like it. They go through a very intensive process. And if someone's parental rights have been terminated, then it is absolutely feasible to understand why they wouldn't want to have their address located in certain areas because of things like parental kidnapping, prior abuse, or any of the many reasons why they may have their parental rights terminated. It is not an automatic put your name in there if parental rights are terminated, but it would be under this bill an option for those to have that private.
So are you saying that the courts would oversee that?
The courts do oversee that, yes.
And that's what you're saying. Okay.
Yeah.
Thank you.
You're welcome. So seeing no other questions, Liza, thank you very much for being here, and I'll see you Friday.
Thank you.
Thank you. As I post my list. Oh, friend Lucy Nolan. Lucy, are you with us?
I am. I'm here.
Hi, I don't
Hi.
see you. Oh, there you are. Hi, Lucy. Please
Hi.
go ahead with your testimony. Thank you for being here today.
Sure. I love following Liza because she pretty much said everything I need to say. But so just my name's Lucy Nolan. I'm with the Connecticut Alliance to End Sexual Violence, and I'm here today to speak on Bill number 123, an act expanding eligibility for the address confidentiality program. And like Liza, we do a lot of work. We are one of the administrators with the Ccadv and the Alliance, and we work with about 8,000 child, adolescent, and adult survivors and victims every year on trauma-informed services. And so, you know, we worked with a lot of people who would be coming and asking to get on the safe at home list. And so what we're concerned about in some ways is that we work with human trafficking victims, we work with sexual assault victims, but I ran this by our advocates today, and there was some concern about working with with people who would come and try to get on the program for kidnapping or for the parental termination, only because they're not trained in that. So they don't, you know, they feel like if the court tells them, you know, tells somebody, oh, go talk to, you know, I don't know, the Meriden group, Women and Family Center, that they, you know, they would definitely help them, but they don't feel like they may not have the expertise to do it. And so, you know, we do a lot of work. We help people with basic needs and things like that. But this is a little bit different because we don't want to create a problem, you know, a different problem. So that's really for us. That's the issue. But we do certainly, and like as Liza said, as long as the Secretary of State can set up some other administrators or assistants, that would be great. And I think maybe like legal services or someone like that would be able to help out in that way. So we do support it, but we're just concerned about the amount, I guess, unintended consequence that could happen if we don't look at that. And then the other thing I just wanted to talk to quickly, I didn't write this in my written testimony, was the bill 5154 with Representative Nolan, because the way he explained it did sort of change the way I thought about it as well. And that I would hope that on anything that was sort of set up for, you know, young adults, that it would have the Alliance's hotlines number on it. We're now doing a text to chat, so people can text the number, our hotline number, and it goes to a chat.
Lucy, can I ask you, for the benefit of those watching today, we are on CTN, and you never know when you're going to come into someone's life at the exact moment that they need it. Do you have the information on what that text line is?
I do. I just have to, sorry, it's I'm working at home. I don't have my card in front of me, but our English hotline is 1-888-999-5545. And that is a text to chat as well as a call. You can call into that. And then our Spanish line is 1-888-568-8332. And that that is not a text to chat yet. We're just started out the English one. So
that's fantastic. Thank you so much.
But yeah, so, and I just think we'd like to, you know, we do have some work. We've done a lot of prevention work and making different kinds of materials for young adults too. So we would love to help, because we have some information. We have one things we're doing right now is we have a deck of cards that are going to ask questions, like questions. Yeah, you'll find out about it in Sexual Assault Awareness Month in April. But
I'm so excited about that. Let's do a big thing about it.
Yeah,
that's fantastic. Actually, I think that's really great.
So yeah, and so I think, thank you. And so we would love to be a part of that as well, because I think it is important. We get a lot of teens and younger people who call us have some questions they may not necessarily want to ask their parents, but they want somebody confidential and safe to talk to. And so, our hotlines are well used. And also we will be having people testifying on Friday as well, because that has been a huge issue, not to get too sidetracked, but that has been the number one issue that we've been hearing from the pandemic is the need for mental health for children. So
absolutely. And this committee is 100% committed to that. And we know that the Public Health Committee is as well. So thank you very, very much, Lucy. We appreciate you. Representative Foster, do you have questions?
Yep. First, thank you so much to your testimony, Lucy. It's always nice to feel like you come full circle. Lucy was one of my first mentors in my undergraduate programs. In her earlier career in her anti-career space, we aligned and had quite a bit of overlap. So it's a pleasure to see you. I'm just curious, you know, as you're here supporting and testifying for this as a representative, a lot of what we do besides working on legislation is also making sure that we're getting information disseminated to our constituents and that we're a conduit of information. Are there things that you recommend that we share with our constituents? To pass on? I have the text numbers that you just recorded, but is there anything you recommend for us to share resource-wise?
So, yeah, you know, we have a sort of smaller website. We have our larger website, but we have a website, just CT All In. And if you go to that, it has a list of sort of 12 different things of how you can stop sexual violence. And it has some graphics and things that people can share, and also sends people to our bigger website. But it's sort of a quick and easy hit when you want to know know something that has some information that way. Everything we have is on our website. Sometimes there's a lot. If you need anything, give us a call. And certainly in your area, you have New Britain Sexual Assault Crisis Center that services that it would love to help you and come talk and do a presentation or something. So as well in your area.
Thanks so much.
There's so much, Jamie. Sorry, Representative Foster. There's just so much out there that you pick and choose.
I appreciate it. It's great to see you, and thanks for being here.
Thank you.
I can see where you two would be great team together. Representative Dauphinay, you have your hand up. Madam, I don't know if that is from the last question or if you have a new one. Oh, she took it down. There we go.
I didn't know I had to hit it. I'm sorry, I just did.
That's okay, Representative. That's all fine. So that means, Lucy, that you're off the hook. Thank you so much.
Thank you. Okay, thank you.
We'll see you Friday. And with that, we are getting very close to the end here. We have 4 more people left to be with us today. We're going to ask for Peter Zara, the national representative of the International Association of EMTs and Paramedics. And then after that, on deck will be Shirley West. Peter, are you with us?
Yes, can you hear me?
We sure can.
Okay, fantastic. Hi, my name is Peter Zara. I am an EMS professional with about a little more than 10 years experience, and I'm also a national representative for the International Association of EMTs and Paramedics. And I'm here to testify in support of Race Bill 5154, but I have a small modification in mind. As Representative Nolan pointed out, this would permit law enforcement to distribute materials and resources to victims of crime and children, and these materials and resources would be much needed resources for improving mental health and to especially these vulnerable populations. Where I see that this should move to is to expand the role of public safety personnel in the bill to include EMS professionals. Many times EMTs and paramedics are frequently first on scene of 911 emergencies, and we encounter these vulnerable populations and children and crime victims. And there is a bond that occurs, if you will, with the first on scene that is difficult to replicate once additional responders begin arriving. So I think the language is good. I think it's a solid bill, but I just would like to see the definition of public safety personnel, the role expanded outside of law enforcement.
Yes, thank you very much for your testimony and for your insight. I will say that I received an email from one of your colleagues over the weekend, and I was thrilled to get it because, you know, usually we have people saying, oh, it's too much for us to do. And here's a great group of people on the front line saying, wait, we should have this too. I just think that that's really incredible. And thank you. We will absolutely include you. And now that we are discussing that this should be for children 13 to 17 years old, I think it kind of changes it a little bit, right? And so a question I just have for you, Peter, is there anything any training that you received to deal with adolescents, is it any different than when you deal with adults?
The training that we receive is fairly generic. We do, from a clinical point of view, we do have some delineation between adult patients and children patients, infants, and so on. But from a mental health perspective, and in that regard, there's very little difference. I mean, it takes when we get on the road, the things that we take out of the classroom are much different, and we just kind of learn to apply it through experience and different situations. But the training itself is very limited in that regard. I think that answers your question.
It does. Thank you. And as you may know, I believe it was 2018 when we passed legislation that brought you guys into the fold for continuing education training on working with autistic children and adults. And that was so important to me because you know, I have 3 nephews who are on the spectrum, and we have often done touch-a-trucks, and we do special needs day in the town of Cheshire, because these kids need to come and get on an ambulance sometimes, and they need to feel comfortable. So one of the things that I'm thinking about now is I'm hearing that you want to be included, and that we are going to now be refocusing it from 13 to 17 years old. Would you say that based on how we write this and put it out, that will actually, could it possibly also help you to make a connection with someone younger and almost in a way serve as a training in how we broach the subject on this pad, would kind of be a bridge and help you to talk directly to children and adolescents?
I think anything like that would be fantastic. The vast majority of EMS professionals nowadays are not that much older than the ages we're talking about, right? So 18 to 25, we are typically seeing as being the entry age into EMS. So I think, yeah, anything like that would be helpful, because how do you really relate to someone? You're in this profession now, so you have this responsibility, but this person's like 3 years younger than you. So it has to be difficult. So yeah, I think any resources that you can provide would help, and any education would help.
Excellent. Thank you so very much. Are there any questions from members of the committee? No? Well, you know what? You did such a great job that everyone feels comfortable putting you in the bill. So
perfect.
Kudos to you, sir.
Fantastic. Thank you for your time.
Thank you very much for being here. And we will be in touch with that, with the language, and make sure that you're all on board.
Perfect. Thank you very much.
Thank you so much. And believe it or not, with that, I think we may be ending the world's shortest public hearing in children's. And given how we can tend to go on, that's a pretty big feat. Jean, I just want to make sure with you that I am correct that is the case. Yes?
Correct. We haven't had any new guests arrive.
Okay. If there are guests that are for some reason trying to get on, having trouble, know that you can always submit testimony, written testimony, by emailing kidtest@cgt.gov. Senator Anwar, any closing words?
Thank you so much, Madam Chair. Thank you everyone for who did come and speak and who sent us testimony. Really, this is part of the process. We start with the concepts, we start with an issue, and then we actually start to put our heads together, do the research, and put something on the paper, and then we start to make it better. And you make it better when you weigh in. And today, a lot of people, what you have brought in has made our bill better. We'll hopefully go back to the drawing board, look at how we can improve things further, and cannot do this without the input of our colleagues, their questions, but the people who come and speak and help us out. Thank you so much, Madam Chair, for your efforts as well.
Thank you, sir, very much. And we will do one last announcement. Jean, because I don't have my calendar in front of me, Jean, can you please help me with the announcement of the next meeting?
The next Kids Committee meeting is on Thursday at 3 p.m.
And then, of course, don't forget the joint public hearing on Friday with the Public Health Committee, where we'll be talking about SB2 and 5001. So with all that, I'm happy to say thank you to every member of the committee and to all our staff, but we are adjourned. Have a great day, everyone.